underlying principle of Goodyear. Now, moving to Section 1064.3 specifically, the cancellation provision that you note, that's on page 11A of our appendix. It says the primary significance of the registered mark to the relevant public rather than purchaser motivation shall be the test for determining whether the registered mark has become the generic name of goods or services. I think it's significant here that that provision was enacted in 1984. Respondent has pointed to no case and no source before its own brief suggesting that it overturned this court's decision in Goodyear.
It was enacted in 1984, but that's a lot closer to today than the Goodyear case, which was 130 years ago. So I don't know why we would focus more on the statutory language than that old case. But more to the point may be that if this is a generic term, Booking.com, that means that it describes a category of goods or services. But when you talk about other companies in that category, whether it's Travelocity, Priceline, or whatever, nobody refers to those as Booking.coms. So Booking.com is not a generic term to describe that type of service.
So again, a few points on that, Mr. Chief Justice. The first is that we agree that in the ordinary case, one might use the term generic to refer or to understand it, how the consumers generally refer to a class of goods, but I think it can also be used, as this court's decision in Goodyear used it, for how a specific entity or how the public would understand a specific term. So, for example, in Goodyear, the court held that Goodyear Inc. could not be, or Wine Inc., for example, could not be trademarked, and that's true even though nobody refers to a class of wine incorporated. The point here is that the distinction—
Thank you, counsel. Justice Thomas?
Yes, Ms. Ross, a couple of questions. Could Booking acquire an 800 number, that's a vanity number, 1-800-BOOKING, for example, that is similar to 1-800-PLUMBING, which is a registered mark?
So, Justice Thomas, under the Federal Circuit's decisions, yes, it could. Those decisions, I think, are sort of debatable under Goodyear and the principles that we think control here, but the Federal Circuit, the PTO rather, does follow those decisions because of the right of direct appeal to the Federal Circuit from PTO decisions. Now, I think it's significant that those are distinguishable in the sense that the core problem with Booking.com is that it allows respondent to monopolize booking on the internet because of the fact that longer domain names of respondents' competitors like ebooking.com and hotelbooking.com can include Booking.com. That is not as obviously true of something like 1-800-BOOKING.
Well, that could be true, but I'd like you to compare this to Goodyear. In Goodyear, you had a generic term, but you also had added a term such as company or Inc., which any company could use. Now, with Booking, here there can only be one domain address, .com. So this would seem to be more analogous to the 1-800 numbers, which are also individualized.
So, Your Honor, you're completely correct that only one internet entity at a time can hold the domain name rights to Booking.com. I think that actually works in our favor rather than respondents for a few reasons. The first is that respondent doesn't actually argue that every domain name should get a trademark, as I think would be the consequence of Your Honor's position there. I think the reason that respondent doesn't do that, again, is because if that's good for respondent, then it's good for ebooking.com and hotelbooking.com, and then I think the risk of confusion analysis on the back end would also have to account for the fact that each of those is unique, and so respondent would wind up with a very thin trademark protection. Putting that to one side, in the usual case of trademark, what a registrant wants is the ability both to exclude others from using the same name and to exclude others from using names that are confusingly similar. Because of the functional nature of the internet, respondent already has that first advantage. So others can't use booking.com online, and their competitors won't want to use those terms in their promotional materials because that will direct customers to respondent's website rather than their own. So the point here, and this is why generic.com terms garner so much money on the internet. The point, I think, of this case, what really matters is the second type of usage, the ability to block out competitors like ebooking.com and hotelbooking.com. And I think that's exactly the type of anti-competitive concern that this court expressed in Goodyear, that if you allow one company to have Booking Inc. or Booking Company, it's going to preclude others from calling their goods by their name and from marketing themselves as what they are. Now, I think, the Judge Wynn explains this very well in the Court of Appeals dissent at pages 28A to 29A of our appendix. What respondent wants here is something it couldn't get in the brick and mortar world. So usually we require businesses to decide whether to adopt a generic name up front, and that allows them to get easy recognition from consumers who automatically understand what they sell. But we don't allow trademarks.
Thank you, counsel. Justice Ginsburg?
Two questions. First question is, if you're right that .com doesn't make a generic term non-generic, how many marks, already registered marks, would be subject to cancellation? I take it there are dozens of .coms that have been registered. Is that so?
So, Justice Ginsburg, I think respondents suggest that there are far more than there actually are. If I could make just a few points on this. The first is that the TCAB, which is how the PTO speaks precedentially, has been consistent on this point, and the examiner decisions in our appendix, as well as the courts of appeals other than the court below. So by and large, our rule is being followed out in the world, so I don't think that there is going to be this huge change. Now, respondent does point to some examples, but I think those examples show a few flaws. One of those flaws is that respondent seems to think that on our rule, the combination of any two nouns or any noun in an entity designation is always going to be generic. That's simply not true. You always have to look at how the two terms are being used. So, for example, respondent looks to Cheesecake Factory, but of course that's not a literal factory producing cheesecakes, it's a restaurant. So I don't think Cheesecake Factory.
I wanted you to focus on cancellation. Who could apply to cancel an existing registration?
So I do believe,
if we rule in your favor, would the PTO itself endeavor to cancel these marks?
I don't believe so, Your Honor. I think that competitors could, under Section 1064, file petitions to cancel registration. And of course, the fact that it was generic would allow cancellation at any point. Now, I think that those same entities could have brought cases previously based on, again, the binding law of the Federal Circuit and the TCAB, which is and was consistent on this point. So again, I think because respondents' appendix sort of greatly overstates the number of marks that actually have been incorrectly registered, we don't have a fear that there will be a huge backlash if the rules change. And to explain a little bit more why I think that's so, respondent points to not just examples like cheese.
And I have another question I wanted to ask you, and it's a follow-up to Justice Thomas. Your answer to the telephone number question, 1-800-BOOKING, was, well, that's the Federal Circuit precedent, but it would be our job in this case to deal with that if the Federal Circuit is wrong. You have another distinction for the 1-800, say, mattress or booking that would distinguish it from the domain name?
Yes, Justice Ginsburg. So I think the other distinction is that, again, booking.com can be encapsulated in longer domain names in a way that 1-800-BOOKING or booking itself really couldn't be in longer phone numbers. So there's sort of a sort of de facto reason why the same competitive risks aren't there. I think it's also worth taking a step back.
Thank you, counsel. Justice Breyer?
Same question. Justice Thomas's question. Good morning, anyway. Justice Thomas's question, Justice Ginsburg, what do you want to say about that? You can have a trademark that is an address, 1418 35th Street or something. You have a trademark that's an address. You can have a trademark that's a telephone number. So why can't you have a trademark that's a .com?
So again, Justice Breyer, and good morning. I think that it is clear from Goodyear that Goodyear balanced these competing objectives that are always true in trademark law in this very similar context of booking company. We think booking company and booking.com are essentially equivalent. All booking.com tells you is that there is a website on the internet for booking. It tells you it's a type of service. That's sort of a classic generic usage. And we think that that follows from Goodyear. Now, Goodyear, as I was saying, sort of balanced these two competing interests. On the one hand, we want to make sure that consumers understand that the good they got last time is from a particular brand, and so we want strong brand identification, and we protect trademarks for that reason. On the other hand, we want to avoid monopolization of language, and I think that's exactly the concern that Goodyear had with Booking Company and Booking Inc., or Wine Company and Grain Inc., in the words of Goodyear, and it's exactly the same concern that we have on the internet here, because again, by using booking.com and by getting a trademark on booking.com, respondent necessarily must want to be able to block out ebooking.com and hotelbooking.com and similar names. I think, again, because respondent couldn't do that in the brick and mortar world, there's no reason why it should be allowed to do it on the internet. Now, you noted that you could have sort of a street address as a trademark, but I think that's fundamentally different because, of course, that's not telling you anything at all about the services. So the registrant there would still have to work to build up its brand recognition in the same way. Provide, in respondent's case, online booking services and all of the concomitant benefits on the internet that go with that, such as, again, the fact that other competitors can't use that name, and the consumers will go to booking.com expecting that to be a site for booking, for online booking, even if there's no particular knowledge on the part of the consumer about that website.
Thank you.
Justice Alito?
What do you think I should do if I think that Goodyear is the case from a different era and doesn't control here, but also think that the Lanham Act similarly was enacted in a different era, namely in the pre-internet era, and that the case law in which Ms. Blatt relies belongs to that era? How can a rule that makes sense in the internet age be reconciled with the language of the Lanham Act?
So I think, Justice Alito, it's pretty easily reconcilable with the Lanham Act, and I want to go back to the Chief Justice's first question about the primary significance test. Again, the primary significance test is sort of cabined necessarily in the statute, at least, to cancellation of a mark that was already considered distinctive. So this comes up in cases like Teflon and Kodak and things where it's a coined term. And so as respondent concedes in their brief, it's a very narrow rule. In 1984, Congress passed this amendment to overturn a specific Ninth Circuit case that had applied a different test in the cancellation context. Now, it is true that other courts have applied similar analyses in other places, but that's because of the pre-existing common law. So for that reason, we think Goodyear continues to control for the same reason that this other pre-existing common law does. But even taking you sort of outside of Goodyear, as I take your question to suggest, even without Goodyear, you have this very basic trademark policy that has always been true, which is that generic terms simply are not susceptible to appropriation by a particular business, even when there's secondary meaning. This court recognized that in 2 cases following the Lanham Act, citing Judge Friendly's quintessential sort of categories of terms. And I think it remains true on the internet, just as it remains true in the brick and mortar world. Again, I think trademark is always trying to make this balance between competition and brand recognition on the one hand and fear of monopolization on the other. And I think the fear of monopolization side here really speaks very strongly to our position because, again, a respondent's view would allow them to monopolize any term. I think it's worth noting on pages 6 and 8 of respondents' brief, their test actually requires them, I think, to hedge as to whether the words oranges or oranges Inc. or I presume oranges.com would be generic. So on their view, oranges remains generic if and only if a survey shows that the public continues to think of that as, quote, the spherical fruit of the same color. I think that would be a surprising outcome under trademark law, whether in the brick and mortar world or on the internet. Now, the other point that respondent makes with respect to the codification of the primary significance test, I don't think it's actually the primary significance test that's the core of respondent's argument. Respondent's argument is much more that that test must always and in all circumstance require looking to survey evidence and giving that survey evidence dispositive weight. I think that's not true under Goodyear, which I think is wholly reconcilable with the primary significance test because Goodyear itself, on page 602 of the opinion, rejected evidence as legally irrelevant that one particular defendant had sort of the best claim to public association. Again, that's consistent with the Lanham Act in section.
Justice Sotomayor? Justice Sotomayor?
I'm sorry, Chief. Ms. Ross, picking up on where you were right now, is it your position that the primary significance test to the public is never to be used in determining what's generic and what's not? Or is it, and if we don't use that test at least in whole or in part, however much you want, what other things would a PTO examiner look to?
Justice Sotomayor, it's not our position that the courts and the PTO can never look to the primary significance test outside of cancellation. Again, I think that the reason why courts and the PTO do that is because the Lanham Act didn't overturn pre-existing common law, and that, again, speaks to why we think Goodyear remains good law. But I think what courts should do in this instance is look to other sources to figure out what, again, a generic term, whether something is a generic term, which usually means whether it is going to indicate the type of good or service. So dictionary definitions are very helpful in this regard. The use by other competitors, like, again, hotelbooking.com and ebooking.com here, and similar sources. What I think what courts and the PTO shouldn't do is give dispositive weight to survey evidence that, as the trademark scholars brief by Professor Tushnet explains, is going to cause some issues in these particular circumstances. So again, because of the functional nature of the internet, because everyone understands that that only one entity at a time can hold the domain name booking.com, surveys are going to misrepresent the number of people who actually understand that booking.com is a business, as opposed to only infer that because of the way the internet works. Now, I think
Ms. Ross, may I?
Really did.
Ms. Ross, may I? Let me stop you there for a moment. I looked at your definitions of booking, and it basically, one definition said booking a hotel. But this service is much broader than that. You can book a hotel, you can book leisure, you can book travel, you can book cars. So that may be a problem with my looking at booking as generic, but my point being that if I look at all the evidence you point to, e-booking, car booking, hotel booking, that a finder of fact could well conclude that booking.com is in fact related to one entity and not to has become more a descriptive word than a generic phrase.
Justice Sotomayor, I think that's both not presented here, and I disagree on the merits. So I think it's not presented here in that respondent has acknowledged, is no longer contesting that booking is generic for the relevant class of services here, and that's the online hotel reservation services. To go to your broader point, I think this actually speaks to the problem with a lot of respondents' examples, which is to say, you're always looking at the particular category and the particular for which the goods or services are being registered and the usage. Now, on this idea that, well, maybe...
Thank you, counsel. Justice Kagan?
Good morning, Ms. Ross. One short question first. I'm right in saying that you're advocating for a categorical rule here, am I not? In other words, you're not saying that trademarks of this kind will rarely be registrable. You're saying that they will never be registrable. Is that correct?
I think it depends a little bit, Justice Kagan, on what you mean by trademarks of this kind. We think that when you're simply appending.com...
generic.com, bookings.com, booking.com.
Sure. So booking.com and other phrases where the combination doesn't add any additional meaning. So I mean to distinguish cases like the courts of appeals have hypothesized, like tennis.net, where there's sort of an interplay between the two words on either side of the period. We don't think that those could necessarily never provide for trademark protection. We just don't think that's really presented here. But in the mind,
is that why the PTO takes a much less categorical position? It says, well, those .coms will typically not add source identifying significance, but it doesn't say never. Why is that? Why is there a difference between what the PTO examiner's manual says and what you say?
So I don't think there actually is a difference, Justice Kagan. I think what the PTO is leaving open, again, is this category, this very narrow category of rare cases that the Federal Circuit and the Ninth Circuit have recognized. I think what respondent would do is to expand that category. I mean, respondent has tried to say that this is sort of the rare case, but as I was explaining earlier, I think basically every generic.com case is going to have this type of evidence because of people's knowledge of how the internet works. So I think we're not asking...
In your brief, you say, you're not making the argument that people go around talking about booking.coms, but you're instead saying that booking.com is generic, and this is on page 44 of your brief, because customers would understand the term to convey only that the company provides online booking services, and the term conveys no additional meaning that would distinguish respondent services from those of other providers. And I guess when I think about that test, I think, well, maybe or maybe not. If the test is what you say, is what is a consumer going to understand, and does the term convey additional meaning that would distinguish the respondent services from others, I kind of think, well, maybe it would. Well, so how does that test go along with the categorical rule?
So I think, Justice Kagan, to the extent that you think it could convey to consumers some additional meaning, that additional meaning, and really the only additional meaning that respondent has ever pointed to, is this idea that it points you to a particular website. So that, I think, both because it's a functional feature of the internet to which we don't usually give trademark protection, and for all of the competition-based reasons I was noting earlier, I think that can't be enough to get them over the line. They've never made an argument. Again, the sort of the key distinction between generic and descriptive terms is that a generic term identifies the type of good or service, whereas a descriptive term tells you something about a feature or a characteristic of the service. So, for example, apple pie, generic for pies, but descriptive for room spray or candles and the like.
Sorry to interrupt. Suppose, Ms. Ross, that you lose on your argument on a categorical rule. Is there something else that you would like the court to include in an opinion about how to evaluate registration claims for generic.com marks? In other words, if categorical is a bridge too far, is there something else that we should be thinking about in terms of saying when it is that generic marks are registrable?
So a few points, Your Honor. I think first we obviously think that the court should follow Goodyear, and so I think what Goodyear said was that generic company terms, quote, without further specification won't be enough to get trademark protection. I think that is essentially the rule that we're asking for here.
If not.
Briefly, Ms. Ross?
Sure. I think we would want at a bare minimum, the risk of confusion analysis on the back end to be extremely sensitive to the fact that what's driving the intuition is the uniqueness of the domain name, and so that equally applies to respondents' competitors.
Thank you, counsel. Justice Gorsuch?
Counsel, I'd like to follow up on that and just give you another minute to continue answering that question. Suppose the court does not accept your bright line rule. How would you advise the court to write an opinion that draws on and points to the sensitivity necessary in this area?
Sure. So a couple of points, Justice Gorsuch. The first is that I think, again, even if the court did not think that Goodyear squarely controlled here, as we do, I think it is very indicative of the right type of analysis in terms of the concern with monopolizing language. As I was saying earlier, I think...
Let's put Goodyear aside for the moment, okay? Again, I know you want us to go there, but put that aside for the moment. What would you have the court say?
Certainly. So I would want the court to recognize, as the Lanham Act, I think, commands, again, in sections 1052E and F, that generic terms generally are not susceptible to trademark registration based on secondary meaning. And so respondent, like all generic.coms, would have to come forward with some evidence other than simply this secondary idea that, yes, this is a term that just tells me that it's an online booking agency, but consumers have come to understand it as something else. I think blurring that distinction could have really bad consequences outside of the .com context. So again, the Oranges or Oranges Incorporated example, where everything is now subject to survey evidence. So I would want the court to make clear.
I guess that leads to my next question, and that is, why aren't existing doctrinal tools under the Lanham Act sufficient? Because we do always, in every case, not just this area, would take very seriously questions about consumer confusion. And it seems to me a lot of your argument on competition law policy issues is concerned with consumer confusion. But the Lanham Act accounts for that. And then it seems like you're also concerned about the use of a generic term. But fair use doctrine is designed to account for that. So why aren't there sufficient doctrinal tools to address the competition law concerns you've raised? And why isn't this just another example of where intellectual property and monopolization concerns intersect, and we have to respect the judgment Congress made in this particular area?
So, Justice Gorsuch, there's a lot in that question. I think that, my first line answer, of course, is that we think that the tools are sufficient. They just point in our direction. Now, I think that the fact that generic terms can't be trademarked even upon a showing of secondary meaning under the Lanham Act is itself enough to resolve this case. Now, moving on from there, you mentioned the risk of confusion analysis. I think it's notable that respondent in their brief says we should get a trademark on booking.com, but if ebooking.com comes, and a large part of that is because we're unique, but if ebooking.com comes along, we should win in a risk of confusion analysis because we were here first. Now, I think if it's sort of good for the goose, good for the gander, if booking.com gets trademark protection because it's unique, then it seems as though ebooking.com should get equal protection because it too is unique. So I don't think that sort of the competition concerns are necessarily resolved under existing trademark law. I think you would actually have to...
Justice Kavanaugh?
Thank you, Mr. Chief Justice. Good morning, Ms. Ross. Respondent says there's no threat of monopoly with domain names because they're unique, and they say they wouldn't, in fact, be concerned about ebooking.com or similar names in their brief. So what are the real-world practical problems you foresee if .coms could obtain trademarks?
Thank you, Justice Kavanaugh. So again, I think the real-world practical problem is, one, I don't read respondent actually to say that they wouldn't think that ebooking.com were infringing. They say, sure, go ahead and register it, but if it turns out consumers are confused, then we think we get the territory and you don't. So I do think there is a very real risk of monopolization in that sense. The other risk, though, I think, is that respondent is already getting, as I mentioned earlier, these huge first-mover advantages from the fact that it and only it can control booking.com on the internet. And so it is asking for this privilege that no business would have in the real world of both getting the really exacerbated first-mover advantages of using a generic name and then also getting the back-end trademark protection. And I guess I don't see why the internet context should permit that, again, given that it already gives respondents these huge advantages. I also think this is sort of at maybe a lesser level, but if it's true that booking.com and presumably every other trademark, or excuse me, every other domain name can get a trademark, then you're going to have this problem where the trademark system is basically becoming a domain name registry system. It's just duplicative of that. And I'm not sure why, rather than following sort of bedrock trademark principles like generic terms can't get trademark protection, no booking company, therefore no booking.com, the court would go in that direction of essentially just having a quasi can't get trademark protection, no booking company, therefore no booking.com. The court would go in that direction of essentially just having a quasi DNR for internet generic.com names.
Respondent also points out that there have been registrations of booking.com in other countries, the EU, the United Kingdom. Can you respond to that?
Sure, Justice Kavanaugh. I think that may well be true. I don't think it's particularly relevant here. Obviously, those other countries aren't focusing or aren't constrained by Goodyear, as we think this court is, and they're not constrained by the Lanham Act, as we think this court is. And obviously, again, I think the Lanham Act preserves that core understanding of Goodyear, which is no company can obtain a trademark on a generic term, even if it shows that the public has come to associate it with its goods. That's all respondent has argued for here.
Thank you.
Ms. Ross, why don't you take a minute to wrap up?
Sure. Thank you, Mr. Chief Justice. So I think our basic points are simple. We think our rule flows directly from Goodyear.com is simply the online version of company, and it tells you only that respondent operates a commercial website via the internet where bookings can be made. We think it's consistent with the Lanham Act's preservation of this distinction between generic and descriptive terms and with longstanding trademark policy. Respondent's rule, by contrast, would require overturning Goodyear, blurring the Lanham Act's line between generic and descriptive marks, and permitting the monopolization of generic terms online. And for all of those reasons, we would respectfully ask that the court reverse.
Thank you, counsel. Ms. Blatt?
Thank you, Mr. Chief Justice, and may it please the court. This case is about how to tell the difference between descriptive names the Lanham Act protects and generic ones the Act does not. For three reasons, this court should hold that the answer is the primary significance test. That is, whether consumers primarily think the name is a genus or a potential brand. First, the Act mandates this test. Second, the Act abrogated Goodyear. And third, this test furthers the statutory purpose to let consumers decide which marks deserve trademark protection. First, the text. The Act has always required in sections 1052, 1091, and 1127 trademark registration if a mark helps consumers distinguish among brands. In other words, the Act protects descriptive names, which consumers find useful, but it excludes generic ones, which consumers think just refer to a genus. The Lanham Act thus codified the law of unfair competition, which had protected descriptive but not generic names. And right before Congress passed the Act, this court in Kellogg adopted the primary significance test under unfair competition law to distinguish between generic and descriptive names. For the past 70 years, courts have embraced this primary significance test to tell the difference under the Lanham Act. And it was against this universal backdrop that Congress later codified the primary significance test in sections 1064 to overrule a decision departing from this test in the cancellation context. 1064 thus reflects Congress's ratification of the primary significance test to define a generic name in all context. The government has no other test for the dividing line other than primary significance. Second, Goodyear did not survive the Lanham Act. The Act repudiates root to branch any per se rule that an island of words are generic as a matter of law, regardless of consumers' views. First, sections 1052, 1091, and 1127 necessarily define generic names as ones that do not help consumers distinguish among brands because everything else must be registered. And the factual question about what consumers think is the antithesis of a per se rule.
Thank you, counsel. You rely heavily on the primary significance test, but that is only in the provision of the statute dealing with cancellation of marks. And of course, this is not a cancellation case, it's a registration case. So why should we assume that the primary significance test carries the weight that you would give it?
Sure. So, like I just said, the 1064, we think, is a ratification of the law as if you were looking at the defining line between what's a generic term and what's a descriptive term. And the specific amendment was to overrule a decision that had come up in the cancellation context. So it was targeted to that Ninth Circuit anti-monopoly case. In terms of the primary significance test, though, if you ignore Section 1064, there is still no other test than one that looks to what consumers think of the mark, because three provisions, regardless of 1064, require registration of marks that help consumers distinguish among brands. So
well, maybe one reason that Congress put this in the cancellation section and not in the registration section.
I don't think that can be right because, again, Goodyear is a common law rule. I mean, let's just talk about Goodyear. Goodyear is a common law rule that is based on the principle under common law that no mark could be trademarked if competitors could, with equal truth, hypothetically say that about the mark. And so Goodyear, by its terms, interchangeably uses the word generic and descriptive marks. And that was true because common law didn't care. Both were off limits. And so the court in Goodyear specifically said wine company is no different than Lackawanna coal and Pennsylvania wheat, which are descriptive terms. And the court said both are off limits. Now, this court in five cases at the time, right after Goodyear, described Goodyear as not only a case about descriptive terms, but two cases, Lawrence Manufacturing and P.D. Beckwith, which are cited on pages 28 of the government's brief for the equal truth principle. And that's where the government, I think it didn't mean to, but it basically says booking does not deserve a trademark because everyone with equal truth could be a booking company. And we know the Lanham Act.
There are a lot of companies that use booking in their the second-level domain. ebooking.com, hotelbooking.com, eurobookings.com, travelbooking.com. If you succeed in trademarking booking.com, then these competitors will be impeded from using that term, which is an accurate description of the services and goods that they provide.
So I don't think that's correct.
Isn't that something that we should take into consideration?
Sure, and like you should take into consideration with all marks that are descriptive. I mean, our bottom line position is that .com marks should be treated the same, but there are three reasons why you shouldn't worry about what the government's, their sort of, concerns about anti-monopolization. First, the concerns are just in a brief. They don't give you not a single example of harm, despite the ubiquity of generic word.com marks and the fact that booking.com is registered in 85 other countries, including ones that...
Could you quickly note what your second and third reasons are?
Yeah, so let me get to the third reason, which I think is the legal reason in terms of why it doesn't crowd out. The more descriptive a mark is, the harder it is for that mark to show a likelihood of confusion, a requisite element in any infringement claim. And the
Thank you, counsel. Justice Thomas?
Sorry.
Thank you, Chief. Getting back to the Chief's question, Ms. Blatt, you seem to rely almost exclusively on the primary significance test. Do you need that test in order to prevail here?
No, because regardless of what you think of our test, the government can't be right because three statutory provisions that don't mention primary significance test overrule, repudiate, abrogate, and completely eradicate any notion that you could have a per se rule that would ignore what consumers think, which is why the court in Qualitex didn't need some primary significance test. It just said you don't have the common law per se bar against trademarking colors. It's just a factual question about what consumers think. Do they find the mark useful? And so we win under three provisions. I think the other problem, even putting aside those three provisions, Justice Thomas, is that there's a whole separate problem the government has, that there are two provisions that require courts to look to how consumers would view the mark as a whole and not its component parts. And so provisions that require courts to look to how consumers would view the mark as a whole and not its component parts. And so you can't just think because wine is generic, company is generic, wine company is generic. And that's the same, with the word container and the word store. You put the two together, booking or .com, you put the two together, and you have to look at the way consumers would view that as a whole. That also abrogates a per se rule. So you don't even need to mention primary significance to know that the government is wrong. It just so happens that every court has always said the primary significance test governs.
Yeah.
The PTO's manual says it. It's the test that was applied in this case. And if I could turn to something that I think is pretty devastating for the government, is their appendix. Their appendix of rejected marks is not based on Goodyear. It's based on the primary significance test. Go look at the records in ad.com, bedandbreakfast.com, bookkeeping.com, limousine.com, newspaperarchive.com. There's no Goodyear. It's the primary significance that looks at extensive evidentiary record about how consumers would perceive the mark. Now, our appendix is not, it's the same. It's not based on mistakes. Weather.com, tickets.com, dating.com, wrestlingfigures.com, and another bed and breakfast mark. The PTO looked at extensive evidence. It wasn't some lazy PTO officer. It was someone looking at the primary significance test and saw, wow, I'm seeing that consumers really see weather.com as distinctive. It deserves registration. So the status quo is the primary significance test, and that's what has been, I think this also should give the Chief and Justice Thomas some comfort that most marks flunk the primary significance test, but some don't.
So you make the government relies on Goodyear, and you say that, of course, there's been a sea change in trademark law since Goodyear, particularly with the Lanham Act. Would you just explain briefly how you think the Lanham Act has expanded the trademark law and what is protected and what is not protected?
Sure, Justice Thomas. So it's a basic overhaul in the sense that, and again, these are these 5 Supreme Court cases that are cited on pages 37 and 38 of our brief, and all the old chestnuts, Elgin and Canal Company, these are famous trademark cases that are all about the bar on descriptive marks. You cannot, could not, may not trademark Lackawanna coal or Pennsylvania wheat or Elgin watch or whatever the typewriter was in the Howe case. You just can't do it because everybody has an equal right to say they have that particular characteristic or that particular...
Thank you, Ms. Blatt. Justice Ginsburg?
If you have a same name, Ms. Blatt, then the consumers will know that the word .com will get you a particular source. Not all sellers of a given service or commodity, but one particular source. And yet you don't argue that generic.com is always potentially trademarkable. So when will the generic.com remain generic?
So in terms of when it flunks the primary significance test, in addition, I'll give you some examples, but the sites that I gave you from the government appendix are good examples of how generic word.com marks flunk it. But let's look at, there's several examples. So in our survey, an overwhelming majority found that washingmachines.com were generic, and yet an overwhelming majority found that booking.com referred to the travel website that's used around the globe. Another example, just sort of a common sense example I can give you, is that sometimes people think of generic word.coms generically. I have searched every grocerystore.com looking for toilet paper. I have now started looking at every hardware.com. I am using fooddelivery.com for all of my takeouts these days. Those are generic usages of a generic word.com. And I think the examples on the PTO's database versus our examples just show you where, and let me just correct for the record here about survey evidence. Survey evidence is never dispositive. You always look at any and all relevant evidence about consumer usages. And if there's evidence from newspapers, consumer surveys, dictionaries, trade journals that give you reason to suspect a survey is either unreliable or just you don't have to credit it, then don't credit it. Then the generic.com mark loses as a factual matter because the evidence is otherwise overwhelming that the mark flunks the primary significance test. It's just here the government tried relying on the survey. I'm relying on all the evidence about booking.com and the lack of PTO's evidence. But other cases will turn out differently.
May I ask you another question? And that is, if passing off another services as your service is what you're really concerned about, why doesn't unfair competition law afford you adequate protection?
So mainly, the reason is because, we're a business. We want the same competitive rights that every other travel agency has to federal registration. But specifically, .com marks need Sections 1125D and D2 in particular, because it allows in rem proceedings. So if you have a cyber scam, they largely arise overseas, and the person is beyond the jurisdiction of the U.S. courts. And what the Lanham Act does, if you're a trademark, it allows you to sue the domain name and basically shut it down. And spoofing, typo squatting, and all these other cyber scams are prevalent among the Internet. But I do think even if you didn't have the Internet-specific reasons, they're not second-class citizens. They deserve the same trademark registration rights as any other company to protect against outright counterfeiting and infringement.
Thank you, counsel. Justice Breyer?
Thank you. What I'm directing your attention to is Professor Tushnetz's brief and McCarthy on trademark, which is against your position. And what I got out of that, it's a combination of four things. One, the trademark law is supposed to give the company the advantage that grows out of a commercial identification. It's not supposed to create monopoly power or market power beyond that. Mm-hmm. Here, the power of the trademark, your trademark, is exactly growing out of the fact that everybody knows there's one com with one name. And if you can do it in the future, you don't have to worry about searching the Internet for toilet paper from grocerystores.com. There will only be one. Grocerystores.com will recognize one and only one. There'll be pizza.com, there'll be cookies.com, there'll be flowers.com, etc. Now, second, the problem is maybe not so bad if that was the only thing that they could use. But there are going to be lawsuits when it's ipizza.com because that's Italian pizza, or fflowers.com because that's fresh flowers, or ebookings.com. So we're creating an area of exclusivity that goes well beyond the name. The third thing they bring out is that, in fact, the identification that you talk about flows simply from the fact that loads of people now know that each Internet company has one name. So the interesting thing about your survey is not the 73% of the people who think that Bookings.com is a single company, but the 33% of the people who think that WashingMachines.com is a trademark special company, which it isn't. And they do that because they know about the Internet. So you're taking Internet power, not just advertising or commercial product power, and multiplying it. And the fourth thing is what Justice Ginsburg said. There's another way to achieve your result, unfair competition law. All right, now that's a lot, but I want to hear your answer to those points.
Sure, it's not really a lot. It's first, there's the statute, that the statute decided the policy decision in our favor. If we meet the definition of a trademark, we get registered. Second, as a policy matter, the Tushnet brief is just wrong. If you look at the pages 94 of the trial court record, that was the government's expert's story, their narrative. The judge rejected it. And if you look at pages 164 and 167 of the joint appendix, our expert trashes that methodology and makes fun of it and says, take out. Go ahead, remove every single person who erroneously thought WashingMachines.com was a trademark, and you still get a 64%, which is huge, brand recognition for Booking.com. Third, the government's appendix just destroys this argument. They reject these marks day in and day out. They don't get registered. Fourth, reality destroys their argument. Where are the lawsuits? Where are the complaints? Nowhere. I don't see any. Our brief at pages 27 and 28 cites rent.com, tickets.com, and travel.com, and then sites like, we just ran out of room to put them all. 123rent.com, rentsusaNow.com, forrent.com. It's endless. The notion that anyone is being crowded out is just silly. It would be one thing if they could explain someone complaining, but the ubiquity of the travel marks and the ticket marks and the rent marks is nuts. And so,
thank you, counsel. Justice Alito.
What would your client's position be if companies that took Booking.com but made very slight variations sought trademark protection?
Yeah, that's fine, and that's why e-booking, we don't object to e-booking. E-booking is not a problem, and I think it's for the two reasons, if I could finish. It's exactly what Justice Gorsuch said. It is the fair use defense allows under Section 1115 B4 that anyone can use the registered name, here it would be Booking or Booking.com, to describe their services, no liability. And also, and McCarthy has a huge thing on this, that the more descriptive the names, these lawsuits just don't work. And that's true with the, it's not just .com marks, Alzheimer's has a foundation.
Your client would not object to the registration of any trademark that simply made a slight variation in Booking.com. That would be fine. All of those companies could register their trademarks.
They are, because there's 1 million booking registrations already.
Answer the question. Would your client object to that?
They don't and have not and would not. Now, if there was fraud and somebody ripping off the goodwill based on Booking.com, I'm sure they'd want to sue, but it would be very hard to bring that lawsuit. Very hard.
My concern with your position is exactly what I think Justice Breyer just suggested. You are seeking a degree of monopoly power that nobody could have had prior to the Internet age. I take it a company could not have registered Booking Company. But because of the Internet, you have Booking.com, which gives you an advantage over other companies that are in that business. And now you want to get even more advantage by getting trademark protection for that.
So if I could turn to the company situation, this is just not true. The Wig Company, which is registered, is celebrating its 50th year anniversary. It's called the Wig Company. There's also the Wig Shop and the Wig Store and the Wig Mart. And so it's not like Wig Company has crowded out wig companies. There are many places that sell wigs just fine. It's not like any generic word.com has crowded out. Weather.com exists with AccuWeather.com. Law.com, there are so many law.com variations that are registered and not suing each other and no one's complaining that you just type in law.com into the database and you'll see it. There's just a lot of registered names. And that's fine in terms of saying, well, that's just, what the PTO does. But the fact that they don't have any anti-competitive harm seems to me telling that you wouldn't want to write an opinion destroying the billions of dollars of goodwill that's been built up in not just .com marks but in company marks. And if you extend Goodyear past corporate designation, the government cited it said company means an association or a partnership. Well, .com is not an association of a partnership. It's a store to buy stuff.
Thank you, counsel. Justice Sotomayor.
Ms. Blatt, I am troubled, as Justice Breyer and Justice Alito are, about the monopoly situation. But I'm also troubled by what's the rule that you want the PTO to follow? They can't trademark under law generic names. Are they required now to run their own consumer perception surveys before they determine that a particular name is generic? How are you okay with the existing rule that I think Justice Kagan read before, which is that there is no per se rule, but that how is it going to change PTO practice, and won't it lead inevitably to the registration of every single common name of every business, and then a expensive legal fight on whether it's become generic or not?
So I 100% agree with Justice Kagan. Our view is the status quo. which is the primary significance test. It's what the PTO's manual says. It's what the PTO has been applying, which is why our appendix and the government's appendix are actually consistent. It shows the PTO day in and day out, rolling up its sleeves, applying the primary significance test. No, you do not have to have a survey. The PTO looks at tons of evidence and says, look, this is just, consumers would see this as referring to any place on the internet that sells these goods. You're not getting registered, and that's the end of the story. And that's why a lot of those marks end up on the rejected list. Now, on our list, when they let in weather.com, they looked at different evidence and said, wow, weather.com has a big consumer fan base and has the primary significance of being a brand. So we got to register that, and that's good for consumers. You want consumers to know when they go to weather.com, they're getting weather.com and not AccuWeather.com. And same way with the dating.com and wrestlingfigures.com. So I hear you on you're worried, but the PTO is up to the task. This is what they've been doing. And we've had their .com marks that have been registered from the late 1990s and 2000s.
If this is a factual question, and a district court is not to give the PTO deference, then what we're going to have is every district court reweighing all of this evidence that the PTO looked at. And frankly, I'm on the margin with respect to your mark, because I would have looked at e-booking and car booking and hotel booking and all of those other bookings and said, this really booking standing alone is generic, even with .com. Now, you point to the Teflon study, but you seem to be saying that a district court who ruled a different way would be wrong as a matter of law. Could that be? Could any survey ever be dispositive?
No. So let me be clear. A district court, and it sounds like we would have lost had you been the trial court, could rule against us based on the survey.
Maybe not. I didn't look at that entire record.
No, but you could. We could have lost at the trial court level. That's the risk you take. A lot of people go the Federal Circuit route because they like Federal Circuit law, and you take a risk. You go usually the district court route when you think you have good evidence.
Thank you, counsel. Justice Kagan?
Good morning, Ms. Blatt. I guess what strikes me is something along the same lines as what has struck Justices Breyer and Alito and Sotomayor, and it's that there seems a disconnect between the primary significance test and these kinds of names. Because the primary significance test is really asking, well, does a consumer understand something as referring to a category of products or instead as referring to a particular product or service? And these names, by definition, are unique, and everybody knows that they're unique. So if you apply the primary significance test to these completely unique URLs, aren't you going to get a bias in the results? And that's true of the survey, the Teflon surveys, but it's true of evidence generally, that it would seem as that you're going to get a bias in the results and more things will seem to be registrable than really ought to be.
Yeah, so great question, and I think I can clarify this for you. So just like the wig company or wig.com, they can be generic for wig companies and wig producers. So it's not just you have to say the wig company. No one thinks the wig company is referring to wigs. It would be, or, it would be generic for a type of company. So it's not just a category of goods. It's the category of the sellers. So if you think of booking.com is no different than the Container Store. You could say that is so unfair that Container Store, the Container Store, because there can only be one, the Container Store. It's the same way with .com. Now, you're right about the internet address, but that would indict every .com mark, even your hotel, Paris hotel booking, because you would always win under the sphere of it could never be generic. And so courts have just been dealing with this, I'd say now for 2 decades, or at least the PTO, that we're treating the .com marks like house marks, store marks, association marks.
Okay. So let me ask you another question that goes back to what Justice Alito said. And you said to him and to the Chief Justice, well, you wouldn't sue ebookings.com or hotelbookings.com or any of a number of variants on the name. Who would you sue? When is a .com going to win a trademark suit?
I haven't seen any. The same reason, though, but let me just be clear, the same reason the Alzheimer's associations and the paper stores and the paper marts aren't all suing each other, because they lose. So these suits don't happen. But why people want trademark registration is twofold. Outright counterfeiting, because Booking.com is a popular name, and we don't want people ripping off or a store opening up. I think if you read the Car.com brief, they show car dealers putting up signs calling themselves Car.com. That's called ripping off. That's called theft, and that's what the trademark laws are about. So you need that. But secondly, I think that they want it for the 1125D. It's a specific problem with spoofing and cyber scams, and that is definitely what the Internet amicus briefs are saying, is that they need this, and that's what Booking cares about. Booking does not like Internet scams and cyber scams, stealing its business and ruining its reputation because, someone infects your Internet and destroys your identity.
Thank you, counsel. Justice Gorsuch?
Good morning. If I understand your point correctly, Ms. Platt, it's that the government's concerns about the competitive advantage are minimized or mitigated by the fact that marks like Booking.com are relatively weak because you're putting together two generic terms. And consumers may well have your company in mind when they see that. You've got evidence, and we can argue about how good that is, but there may be no consumer confusion. And that may also be true with e-booking or hotel booking. Consumers may or may not, depending on the facts, have particular companies in mind. And the relative weakness of the mark is your answer, together with the fair use doctrine, to the government's monopoly concerns. Is that a fair summary?
Much better than I said.
Will you expound on that, please?
Sure. So, and let me just help you with the reason why they're so weak to begin with, and why McCarthy has this whole chapter of every lawsuit where, similarly worded marks can't sue for others. Let's take weather.com and AccuWeather.com. So it turns out that consumers, when you have very descriptive marks like both of those that are registered, consumers become very conditioned to focus on the difference. So they know Accu is different. If you look at booking and e-booking, consumers would focus on, there's the E site, there's the E one, I want to go to the E one. And so it is very, very hard to show likelihood of confusion, because the more similar the mark is, it becomes extremely impossible or exceedingly unlikely to be able to prove that. And that is not specific to the .com context. It's the same problem that every mart, shop, source, place, exchange, emporium, collective, we have, there's a million dog marks, a million coffee marks, a million paper marks. They all have different store, shop, place, very similarly worded. They never sue each other. And if they do, they lose. And I'm not making it up, Justice Gorsuch. They had a whole brief to cite examples of lawsuits.
Yeah. Can you address for me a little bit more on the record? I know we're not the trial judge here, but Justice Breyer's point, I think 74% of consumers recognized Booking.com as your client, but 33% think that anything.com is a real store. So only about, as I understand it, about 41% on a net basis recognize your mark. What do we do about that? What should we say in this opinion, if anything, standard, if not the facts?
Okay, so you've read the Tushnet brief and the government's brief. You have not obviously read our expert that explains how humorous.
That's not fair. Now, come on.
Okay, so why it is so funny is that you would never net them out. You don't take 74 and subtract 33. It's just based on a very lack of understanding of survey methodologies. You net out the participants, and so when you net out the participants, you say Lisa Blatt dumbly thought washingmachine.com was a brand, so we're going to take her out of the survey. So for you look at the people who correctly saw washingmachine.com as generic, 64% still saw Booking.com. And so I guess I can say is there's just an extensive discussion of this in the JA.
I understand that. I'm trying to abstract just a level up from the facts.
Okay,
and ask for your guidance as to what the court should say with respect to these kind of survey methodologies, if anything?
So I think...
Briefly, Ms. Blatt. Ms. Blatt?
Oh, yeah, I'm sorry. So what I would say is that, the survey instructs the consumers, the participants ahead of time that office supplies is a common, officesupply.com is generic. And if they didn't understand that, they couldn't take the survey. That Staples.com was a brand and officesupplies.com is generic.
Justice Kavanaugh?
Sure.
Thank you, Mr. Chief Justice. Good morning, Ms. Blatt. I want to make sure I understand what you think about our precedent in Goodyear exactly. Could the principle of Goodyear still have some value outside the .com context, in the classic company context in which that case arose, because the .coms are inherently unique, or is your position more broadly that Goodyear just has no value anymore?
So our fallback is certainly you shouldn't extend it to .com, because .com is closer to the word store and shop. But if you took Goodyear at its word, you're killing nonprofits because of the association problem. Goodyear, the terms of the opinion say it means association, and that's how nonprofits identify themselves. So we have, or a coalition or a society, and so you have the Amputee Coalition, the Christian Coalition. There are so many of these associational marks that I think Goodyear would destroy, in addition to Foods Co. or Container Store. And I just want to say one thing about the government's making fun of the Cheesecake Factory. Crab House is not a literal house where crabs live. They're actually dead and you eat them, and the government thought Crab House was generic. So if you go down this road of thinking that certain words are off limits, I just think you're creating a real mess that's very unstable, unprincipled, and unworkable and unclear.
Okay. Picking up on Justice Kagan's line of questioning, it seems that your rule invariably will lead to a situation where most every .com business that sells goods or services will be able to obtain a trademark. Maybe, in other words, your position leads to the opposite kind of bright line rule. Maybe that's okay, but is that wrong? And if so, when wouldn't it?
I think it's wrong, but I hear at least 6 of you concerned about it, so I can try to help on this. What you can do is make clear in your opinion that a district court, if there is evidence of from all kinds of sources that the PTO uses, and all those examples I gave in the beginning, they cite all kinds of examples proving that generic word.com marks flunk the primary significance test, that the PTO can look past survey evidence, and so can courts. If you're really worried about a survey bias. Now, we have a whole brief of survey experts saying this was a great survey. So I hate to trash our survey. A lot of people thought our survey was great. It's the classic Teflon survey. But also, let me just take you to Waffle House. Waffle House, there was a fight about the survey. The PTO said it was generic, and Waffle House came in with the survey, and they trademarked it. So I don't know why .com is having some sort of, it's scary and therefore it should be treated differently because of this fear that all .com marks have an unfair advantage because of a website. The PTO has been doing this for 2 decades now without a problem.
Thank you, counsel. Ms. Ross, you have 3 minutes for rebuttal. Ms. Ross, 3 minutes for rebuttal.
Thank you, Mr. Chief Justice. Sorry about that. If I could just focus on 3 main points. First, I think respondents' rule operates from the presumption that the Lanham Act knocked out all prior common law unless it was expressly preserved. That's the opposite of the way that we usually think about statutory change. I think just a couple of weeks ago in Romag, this court, 9 justices looked to the common law to determine what the Lanham Act preserved, and I think the same should be true here. That's particularly so because in the examples that respondent cites, like the geographic terms and descriptive terms, Congress was clear when it wanted to overturn pre-Lanham Act precedent. I think on the second point, respondent suggests that the primary significance test did it. In particular, I think I heard my friend to suggest for the first time today that Kellogg itself did it. That's inconsistent with the position that they take on page 22 of their brief, which acknowledges that Kellogg actually discussed the primary significance test to determine when a descriptive term would get protection under unfair competition law. So that's entirely consistent with the view here that generic terms are never susceptible to trademark, even with primary, or even when a showing of secondary meaning has been made. Again, we think that the primary significance test coexists with prior law, which includes Goodyear. And I think respondent points to this idea that the PTO has been applying the primary significance test. That's true with the Goodyear sort of guardrail. It understands that a generic term can't be made into a trademark simply by showing that a bunch of consumers think that it's associated with a particular mark or a particular brand. Now, respondents' examples, actually, our respondent survey actually proves this point. There was a lot of back and forth about washingmachine.com versus booking.com, but I think what's really instructive here is washingmachine.com versus supermarket. 33% of respondents in respondent survey thought that washingmachine.com was a brand name. Zero, not a single survey respondent thought that supermarket had that characteristic. So clearly the .com context is doing a ton of work on respondents' view. The third point that respondent really hit was this idea that there wouldn't be any competitive harm from respondents' rule. I think that's clearly not correct. We know that because of the same reason that we know that booking companies shouldn't be allowed to be trademarked. We just know that when you have that trademark law is not supposed to take terms off the table that everyone needs to describe their goods. I think, respondent focused on certain examples like tickets.com and Container Store. I think, again, respondent is misunderstanding that you have to always look at what those are registered for. So tickets.com, for example, for ticket management services, not for tickets generally. So they're massively overstating what's going on here. I think, again, there might be hard questions at the margins on some of these, whether something like container or tickets is being used in its generic sense, but that's not reflective of the .com or the company. That's at that first root level. Finally, I think if they're not going to sue ebooking.com and hotelbooking.com, it's really unclear what they want out of this. Ripping off, respondent referred to, is covered by unfair competition. Typo squatting, likewise, is covered by unfair competition. And Section 1125D, which respondent pointed to, presumes that you have a pre-existing trademark like Kodak or like Xerox or like Teflon in the old days, and someone goes along and gets a trademark.
Thank you, counsel. The case is submitted.
Honorable Court.
This was the first of 10 cases that will be argued over the next 2 weeks using telephone conference calls and letting the public listen in live as the arguments are made from homes or offices. The National Constitution Center will discuss the history-making moment and the trademark case argued today. Live coverage begins in a moment.
the United States and C-SPAN watchers and friends from across the country can evaluate the arguments for yourself. I do want you to do some homework after this show, which is to read the briefs in the case. Really, the best way to understand what we just heard is to go to the Supreme Court website, supremecourt.gov. You'll find the briefs right on the homepage under the name of the case. And after our discussion, you can really dig in to the arguments on both sides. Make sure you read the briefs on all sides so that you can make up your own minds. And with that introduction, it's my great pleasure to introduce three of America's leading trademark scholars who will join us today and help us understand the arguments we've just heard. Rebecca Tushnet is the Frank Stanton Professor of the First Amendment at Harvard Law School. She filed a brief of trademark scholars on behalf of neither party in the Booking.com case. Margaret Duncan filed a brief in support of respondents in the Booking.com case. She is an adjunct professor at Loyola University Chicago School of Law, and she filed a brief on behalf of the Intellectual Property Law Association of Chicago, where she is vice chair of the Amicus Committee. And Corinne McSherry is legal director at the Electronic Frontier Foundation, which filed a brief in support of the petitioner in Booking.com. Rebecca, Margaret, and Corinne, welcome to all of you, and thank you so much for joining.
Thank you, Jeff.
Thank you. Wonderful. Rebecca, Professor Tushnet, let's begin with you. First of all, congratulations. Your brief was cited several times during the oral argument, the brief you filed for trademark scholars on behalf of neither party. But before delving into your arguments in that brief, can you please, as concisely as possible, tell us what this case was about? What were the main legal arguments on both sides, and what are the stakes in the case?
So I think the core question is, at what point does the fact that consumers are likely to recognize something that is, a generic term for a group of goods or services, but it has a prominent provider, and so people are likely to associate the provider with the generic term. At what point should that convert into some sort of enforceable trademark right? So we don't want people to get a monopoly on a term just because they're the most well-known provider of it. But there is a countervailing concern that at a certain point, if somebody really is associated with the term, then there's a potential for confusion if other people use the term, even if there are strong reasons they should be free to use the term in some way. So Booking.com is a good example because through marketplace success and advertising, it has developed a reputation, but it also allows you to make bookings online, which is pretty much what you would expect from any online reservation service. And so having control over Booking.com presents at least the potential for preventing other people from doing reasonable things like Booking.net. And it's actually a significant judgment call whether we should give Booking.com basically a tiny little right and then let it see where the right goes in specific cases, or whether we should say, no, the game is not worth the candle. The risks that will be asserted anti-competitively are so great that it shouldn't get a tiny little right at all. And this is just a big question in American intellectual property law generally.
Thank you so much for that. So I hear you saying that this question of whether by putting .com at the end of a generic term, you should be able to trademark it, and whether that becomes a descriptive term is an open question. We heard in the argument a lot of discussion about what the relevant legal source of authority was. On the one hand, the Trademark Office argued that this case called Goodyear from the 1880s said that generally you can't trademark a generic term like rubber. On the other hand, the respondent on the other side, arguing for Booking.com, said that this federal law, the Lanham Act, passed in the 1940s and amended in the 1980s, came up with a different test, which was the primary significance test. How would people understand the phrase? Would they see it as a generic phrase or as something associated with a particular brand? So those are the kind of arguments we have to unpack. And I'm going to begin in the order that the court did. Friends who are watching on C-SPAN, the first party is called the petitioner. The second one is called the respondent. Here, the petitioner was represented by Erica Ross, who works for the Solicitor General's office for the U.S. government, and the respondent was Booking.com. We're lucky to have Corinne McSherry, who filed a brief on behalf of the petitioner for the Electronic Frontier Foundation. Corinne, so glad that you're here, and I want you to distill for our C-SPAN friends the essence of the petitioner's argument as you understood it. At the very end of the case, Erica Ross summed up the claim that a generic term can't be turned into a particular trademark by showing that a number of respondents think it's associated with a particular mark. And she said that the relevant question, and this was at the very beginning of her argument, was that the secondary meaning or the way people understand the term is simply irrelevant. A generic term like Booking.com is never trademarkable merely by adding something like .com or .inc at the end of that name. So distill for us what, in your view, the petitioner's core argument was.
I'm happy, I will do my best, but I would be remiss if I didn't note that it's interesting to me that for this oral argument today, we had two women arguing on either side in this historic moment, which is exciting. And then we followed it by this panel, which is also all women. And I think that's notable and exciting and worth acknowledging. Yes. So into I think that the key to the petitioner's argument is this. It says, look, under Goodyear, this law from 1888, or this ruling from 1888, it's pretty straightforward that if something is generic, that's it, full stop, we're done. We don't have to get into the primary significance test necessarily. That is something you think about when you're talking about whether something's descriptive or not. But that's not what we have here. We have two, and also there's sort of two generic terms. .com, purely generic. Booking, purely generic. This is a purely generic term, full stop. We don't have to get into survey evidence. We don't have to get into all of this stuff. The PTO can make a decision that this is a purely generic term, and we're done with the argument. And that's essentially what happened here. And I think what was interesting to me as I was hearing the justices really struggling for a rule. I don't know that they're comfortable saying that Goodyear controls for the internet, but neither did I hear them saying they were comfortable that the Lanham Act controls for the internet. And I think I was really hearing them sort of groping for how they should rule, recognizing that whatever decision that they make is going to have enormous consequences for trademark law and the domain name system. And I thought that was very interesting that on the one hand, there was a little discomfort, for what I heard, with following Goodyear, which obviously I think they can follow Goodyear, that's fine. That was the argument that we made. But also I heard discomfort with following the respondent's interpretation of the Lanham Act.
It was indeed interesting. And as you say, it was Justice Alito who raised precisely that point. He said, what do you think I should do if I think Goodyear is from a different era and doesn't control here, but I also think the Lanham Act was enacted in a pre-internet era, and the case law on which Ms. Blatt relies makes sense in that era, but perhaps not our own. Margaret, can you please sum up, in your view, the essential argument that the respondent Booking.com is making? What is the test that Booking.com is arguing should prevail? And what's your response to Justice Alito's question about whether neither Goodyear nor the Lanham Act may provide clear answers in the age of the internet?
Well, and I wrote an amicus brief on behalf of the Intellectual Property Law Association of Chicago. Our view is that the flexible test, what does a particular trademark, which is generally, are a lot of times generally word marks, does that mark have a primary significance to the relevant public for those particular goods or services as a brand, as a trademark that's protectable under the statute? Or is that word for these particular goods or services primarily just a generic term? And the problem is, and in this case, what was raised is, should that be a very bright line test, which is what the U.S. Patent and Trademark Office is arguing for, or should that be a flexible test? And the flexible test is actually in the trademark statute itself, in 15 U.S. Code 1064-3. And that test says we look at evidence of what the primary significance of that particular term is to the public. And I've been practicing in IP law for 39 years, and we have always looked at what is the evidence. Let's look at the evidence. It's a factual question, and determine that answer. We don't use, or we haven't used, I don't think any circuit court has adopted a bright line test to just say, stop, you're out of the game, it's generic, no trademark registration. I think they've always looked at the evidence and used a flexible test, which is enunciated in the statute.
Thanks so much for that. So as I hear you helpfully explaining, part of the dispute is whether a generic term can ever be trademarked if it acquires secondary meaning as tested by how people understand it, or whether no, the fact that people come to understand a generic term as being associated with a particular brand shouldn't matter. Now, Professor Tushnet, your brief was cited several times, which C-SPAN viewers is unusual for a single brief to be cited during both sides of the argument, so congratulations to Professor Tushnet. But it sounds like part of the dispute was precisely this question. You had expressed some skepticism about the consumer surveys that were used, and you noted, as several of the justices did, that washingmachine.com was mistakenly viewed as a brand by some people in the survey, even though it wasn't, and you thought that that should undermine the conclusion that 70-some-odd% of people understood that booking.com was a particular brand. So tell us more about this empirical dispute and what legal consequences you think that it has for the case.
Okay, so here's the basic question, and it really is a policy dispute. I'm not sure that the statute actually answers it, but the analogy is, it's a question that it turns out a bunch of people find difficult because it's not a layperson's question. Because as a practical matter, a .com is its own, one source. That's how the domain name system works. So people don't think of it as having source significance versus non-source significance. So they find it a hard question to answer. So here's how I think of it. So say you asked a bunch of people to solve a complicated math problem, right? And then you look at the people who managed to solve it, and then ask some questions. Who managed to solve it? A substantial majority also get some other question right. Does that mean that most people got the question right? No, it means that most people who were able to understand this other concept got it right. Unlike most surveys, which disqualify a small percentage of people, because there's always some stuff that happens in surveys. People give wrong answers intentionally or accidentally or whatever. They don't understand something, so you exclude them. That's usually a small percentage. The problem here was even after they don't understand something, so you exclude them. That's usually a small percentage. The problem here was even after they trained people on the difference between cereal, a generic term, and Kellogg, a trademark for a producer of cereal, and even after they told people not all .coms are trademarks, even after that, 33% basically thought, oh yes, all .coms are trademarks, and an additional 6% weren't sure. So 40% of people who had, in theory, gotten through this screen couldn't make the distinction. And again, why should they? It's not something that's relevant to them in their daily lives. So that's the question of, are surveys a good way of even getting at the thing we're interested in, or are they asking a question that is just not fitted for a survey? And I don't think the statute answers that. And so this is the question. How do we determine what booking.com means is, and actually the relevant law, I think, is much more from a early 20th century case about Kellogg and shredded wheat. So the issue there was shredded wheat had been patented. People knew one producer of it, so they tended to associate shredded wheat with that one producer. The patent monopoly ended, and other people got to make shredded wheat. Could you make it? And could you call it by the name that people have been accustomed to call it by? And the court said, in that case, that even if there's a powerful association with one producer as a de facto thing, you still can't prevent other people from using the generic term. So this is, I think Margaret's absolutely right that we do an empirical study, but we have always before had as a backstop, sometimes the empirical question is not enough. Sometimes, if there's a good competitive reason to let people use a term, we let them use it, subject to a duty not to fool people. So you can use the term, but you have to use your own trademark with it. Things like that.
Thank you. That's very helpful. And that is precisely what Justice Breyer said when citing your brief. He said the power of the trademark is everyone knows there's one trademark with one name, grocery.com, pizza.com, flowers.com. Maybe that's not so bad if it was the only thing they could use, but there'll be all sorts of lawsuits about iPizza.com for Italian pizza or ebookings.com, essentially that would prevent other companies from using pizza or bookings in their name. And that would create an area of exclusivity that he said might create monopoly power. Now, it is, Corinne, tell us, first of all, one of our questioners, Cassidy Bingle, asks, what is the test Ms. McSherry mentioned? Can you explain it? So do give us a sense of precisely what test you're urging on the court. And then tell us more about the anti-competitive concern that Justice Breyer and Professor Tushnet just identified. You're concerned in your brief that if the court rules for Booking.com, then no one will be able to use any name that includes booking in it if they have hotels or other similar services, and that would give Booking.com a huge and unearned monopoly. Tell us more about that concern.
Well, I'm actually, and I'm not even necessarily solely worried about Booking. I mean, that's the company, you know, that's what is at issue here, but it's more a question of obviously the precedent that this is going to set for other companies and other situations. And the reality is that on the internet, and I think many people sort of just understand this intuitively, whenever you have, you know, generic.com, you're already and you've already registered that as a domain name, you've already gotten yourself an enormous commercial advantage, right? So you've already put yourself ahead of the game. And historically, the way we think about things like that is we say, and this is on brick and mortar land as well as online, is that when you make a choice when you choose a name. You can choose a generic name, and that's going to give you a certain kind of commercial advantage out of the gate, because when people are looking for that kind of service, they will go to you more. They will more likely go to you. When you add that, when you've also registered it with .com on top of that, you've cemented a powerful, powerful commercial advantage. But the trade-off for that is that you don't get a trademark in it, right? So you get a certain kind of commercial advantage, but you give up another kind of commercial advantage. And, you know, that's been a long-standing way of thinking about genericness. The test that I was referring to, and this is the PTO's argument, but I think it's one that makes sense, is that when we talk about the primary significance test and this primary significance question, that really comes, and secondary meaning we've been talking, is that when you have a purely generic mark, you don't get into the secondary meaning situation. You don't have to get into survey evidence. You don't have to get into all of that because really, again, it comes back to that choice that a company has made out of the gate, that it's going to have choose one kind of commercial advantage, that what comes from genericness, a generic choice for their name, and giving up another kind of commercial advantage that comes with getting a trademark. And so that, I think, is the key question here. And the worry that we have is that, not just for Booking.com, but for any other kind of company, that will make this generic choice, they'll register it for the domain name, and then other companies won't be able to come along and really compete effectively, because the trademark owner will already own the domain name and the trademark, and so we've basically closed off a huge amount of space that'll make it very difficult for other folks to come in. And I think that in an era that we have right now, where you have a lot of concerns about sort of the tech giants and a lot of concerns about competition in the online space. It seems to me, as a matter of policy, any ruling that cements that anti-competitive situation is a dangerous one for the internet. And really, that's who my organization represents, is internet users, small business owners, who are really looking. And we also generally try to protect competition online because we think that's how you get better innovation. The danger of this situation is we're going to undermine that kind of competition.
Thank you for that. Thank you for explaining your test. Just to repeat it, to make sure we all understand it, that this primary significance test should be relevant for a descriptive mark, but not for a generic mark. If you have a generic thing like booking or weather, you shouldn't get into the question of how people understand it. It's only when you have something that is more descriptive of the product being described. Let me ask you, Margaret, what would be the consequence of a ruling against you? Lisa Blatt, who was arguing for the respondent, said there are already plenty of these generic marks that have a .com trademark, weather.com, dating.com, breakfast.com, and she suggested that all of those could be challenged if the court ruled against booking.com. And Justice Ginsburg asked the same question. It was her very first question out of the gate. She said, who could apply to cancel existing registrations? And then that led to a question of whether even trademarks for things like 1-800-bookings, or as Justice Breyer said, for a particular address, 1445thstreet.com, could be challenged if the court rules against booking.com. So tell us about your response to the practical effects of a ruling against you.
Right. I heard in the oral arguments, and I want to also express that I thought both women did a remarkable job, just an outstanding job on the historic oral arguments today that were for the first time in the history of the court by telephone, which is a difficult thing to do. And then to do such an excellent job was just remarkable for me. I do want to say that trademarks are tricky. And whether a word is generic or whether a word is descriptive is a factual issue, and we need a test so that you can determine that answer, whether you are at the Patent and Trademark Office or whether you're in front of a jury or a judge. I think a flexible test, again, works well. I think if you had a bright line test that said, oh, this mark is generic, that's the end of the story, we're not going to look at any evidence. And by the way, the evidence can be other things than surveys. It can be newspaper articles and magazine articles. It can be dictionary definitions. It can be a lot of different evidence. But the truth of the matter is, in this case, the survey evidence showed that 75% of consumers, whether the survey was flawed or not, that 75% of consumers in this particular survey thought that booking.com was a brand, not generic. But the tricky part is, there's a sliding scale of trademarks. They're very highly protectable trademarks that are completely coined words or arbitrary and fanciful words that have no real meaning, like Xerox. And then there are words like Apple that do have a meaning, but when combined with a good or service that doesn't have anything to do with apples, the fruit, they're very highly protectable because an apple doesn't tell you that the goods or services are computers. What's interesting is descriptive marks tell you something about the goods or services, but they don't necessarily tell you completely what they are. So if we had clothing that had apples all over it, would that be protectable with the trademark Apple because it does describe a feature of the goods or services? That's the question of trademarks. That's why it would seem that in all trademark law, a flexible test, which is what is the primary significance of that word or term to the consuming public, and is that just purely the generic word, there's no other way to describe that goods or services than that word, or is it descriptive? And if it's descriptive, the flexible test really works well to determine that because it's factual, it's not subject to bright line yes or no. It really does have to be looked at based on the evidence. If I say, I made a booking today. Do you know if I bet on a football game? Do you know if I reserved an airline ticket? Do you know if I was just hitting the books hard and I was booking it today? I mean, it's really a factual question that a jury, or in this case, the PTO examiners, have to determine. And I think a flexible test is the best one to apply.
Thank you for that. Thank you also for noting what a superb job both women did in the case. And also, it's striking how successful the arguments were. It was unusual. Ordinarily, of course, advocates are asked questions by whatever justices they like. It's a very intimate give and take. It's very conversational. Here we had a formal running down of the justices in order of seniority. All of the justices asked questions, including Justice Thomas, and they were quite respectful of each other. They made some jokes. They said good morning, but generally it was with the occasion of one or two pauses where someone was getting off of mute, the whole thing ran pretty smoothly. So with that, Professor Tushnet, let's dig into the questions by the justices that struck you as most significant. The very first question out of the argument was that of Chief Justice Roberts. He said, "Counsel, you mentioned the Goodyear case, but you didn't quote the language from the trademark statute it issued here. The primary significance of the mark to the public shall be the primary criteria." He said the Goodyear case had a different test. Shouldn't this statute, which came later for the 1940s as amended in the 1980s, matter more than Goodyear? What was the significance of that question? And more generally, which questions by the justices would you like to share with our viewers and friends as being especially significant?
So I actually think that first question is a really helpful one, and it connects this case to, so I think it's actually rather unfortunate, but the court is increasingly taking the position that the statutes and the Constitution will clearly mean one thing, just read them, can't you see? And this means that they often struggle in cases involving things like the Lanham Act, where the Lanham Act is actually explicitly enacted on top of about 100 years, give or take, of American decisions creating a common law of trademark and unfair competition. And so the court does not have the best tools, or has abandoned some of the tools in the judicial basket for dealing with statutory language that has some sort of common law basis, or was enacted against a backdrop of making certain specific changes to the common law. And the primary significance test is actually a great one. And fortunately, the justices' discussion indicated that they actually were pretty clear on what had happened, which was in the early 80s, a court had invalidated the trademark on the game for monopoly on the theory that consumers wanted the game Monopoly, which they understood to be a unique product, and therefore it wasn't a valid trademark because the product was unique. This reasoning is problematic because it also applies to my beloved Diet Coke, which is in fact unique, although it is just a type of soda as well. So Congress wanted to make sure that no one could say, well, because people want the taste of Diet Coke is not a valid trademark. So they didn't actually address, the amendment didn't really address the question here, which is if it's not because it's unique, but because it refers to pre-existing meaning, is that generic? How do we figure out what that means? And so primary significance makes sense when you're asking, do you think that monopoly refers to a specific game from a specific producer? It doesn't necessarily make sense when you're talking about shredded wheat, which until a year ago had only one producer.
Many thanks for that. Corinne, I want to make sure I understand, and all of our viewers do, the precise difference between the 5 categories of trademarks listed in order of distinctiveness and protectability: first, generic; second, descriptive; third, suggestive; 4, arbitrary; and 5, fanciful. I feel like I'm back in a wonderful English literature class, but just so we're all learning together, remind us one more time exactly what the difference between a generic and a descriptive mark is, and then tell us why it is that as things become more specific, more suggestive, more arbitrary, and more fanciful, it's more okay to trademark them, and then maybe call out a question from a justice that you found especially significant or telling.
Okay, that's a lot of stuff.
It is, but we got to understand it.
But let me get to what I think is the key issue here with trademarks. The idea is that we want to have a spectrum from purely generic to purely fanciful. And I do think that the line between generic and descriptive can get kind of tricky to figure out. But the sort of core question that's always confronting the PTO and trademark owners and all of us who are working in the space is, the more something is purely fanciful, purely arbitrary, the more it looks like it's fine for that to be owned, technically owned, controlled by a particular entity, because it's not going to impede competition. It's going to do what trademarks are supposed to do, which is identify the source of a good so that consumers are in a position where they can say, like, yes, I want Coca-Cola. I don't want Pepsi. I don't like Pepsi. I want Coca-Cola. So Coca-Cola is more fanciful, and there's the logos associated with and all that kind of stuff. And it helps consumers make that choice, that they are choosing the particular kind of particular brand that they want, and that, and it will taste a certain kind of way, and that's what they're after, without controlling language. And that's really what a lot of the troubles with trademark are, is what you don't want to have is a situation where somebody can really control too much of language altogether. One of the things that I think is interesting here is that, a thing that Booking.com could do, they could have fanciful logos, and they could trademark those, and then no one's really arguing about that. It's only when you're talking about something where it's like purely .com is just, it's like company, it's like any other thing, and in fact, .com was designed to be equivalent to company or incorporated when the domain name system was established. That was the basic idea. In terms of a question that I think was interesting, what I saw is a whole series of questions where I saw the judges being worried. They're worried about the implications of this ruling for the internet. What situation are they going to create for companies down the line? How do they come up with a rule that isn't going to set up a few companies in a position of being able to shut down all of their competitors? And I think that the answers that I heard were not completely satisfying. So, for example, there's an idea, well, these kinds of trademarks aren't really litigated all that often, but if you're a small company and you can't afford that litigation, that's full stop for you, right? And a lot of times what happens too is that things don't get litigated because they get shut down before they ever get to litigation. And that's the kind of situation that I worry about. And the other thing that I heard is that because I heard a number of questions too, I was like, well, what does Booking.com really need this for? What's the point? They've already got this commercial advantage already. What are we really fighting about here for them? What are the stakes for them? And I thought it was interesting that Ms. Blatt said, well, what we really want is to be able to bring in REM actions. And that's interesting, because what the shorthand for that is, these are situations where you go to court and you want to go after someone offshore and get an order from the court, basically trying to shut down access to that website. And that's a very, powerful or burgeoning area of law, effectively site blocking injunctions from courts. And I thought that was telling, because I didn't see that in the briefing, but I think that's actually really what Booking.com wants. They want the ability to go and shut down offshore copycat sites via site blocking orders. And that's really the stakes here. And I think that's very interesting as well.
Thank you for that. Well, Margaret, it's worth responding to that suggestion. Is that what Booking.com wants, the ability to shut down off-site marks? Maybe I'm going to ask one more time, because I need to make sure I understand the distinction in order to be able to explain it. The distinction between generic and descriptive terms, the PTO's brief says that a term that begins as generic or becomes generic over time can never be trademarked. By contrast, a descriptive term which describes the quality of a goods or service, like after tan, post tanning lotion, or yellow pages, can be protected as trademark, but only if the registrant shows it's gotten a secondary meaning. It's become distinctive of the fact that it's the yellow pages, which everyone recognizes. And then the question in this case is whether, in the age of the internet, it would become too easy to turn a generic phrase like booking into a descriptive one simply by the fact that you spend a lot of money advertising and people come to associate it with a particular website. So responses both to Corinne's concern and also an attempt to help us understand that distinction and why you're not concerned that the internet world changes the distinction between generic and descriptive terms any more than it is in the non-internet world.
Right. Well, the trademark statute, 15 U.S. Code, was definitely not written with the internet in mind. In fact, the internet did not exist that I know of in the 40s when the Lanham Act was first enacted by Congress. I think that to have one rule for trademarks for .coms as opposed to another rule for other types of trademarks is a slippery slope. I don't think that necessarily Booking.com, I mean, certainly all trademark owners want to shut down copycat sites or false sites that are pretending to be them, but you're not really getting the generic, you're getting a copycat, you're not getting the genuine goods or services. And they want to shut that down, especially to protect the consuming public from not getting the same quality of goods or services on a copycat site that you might get on the real site. But I think their main goal is really to protect their brands, just like Coke wants to protect or Pepsi wants to protect their brand so that every time you use that particular product, you'll get the same quality. I think Booking.com is really trying to say, if you come to this website, Booking.com, as opposed to another reservations or hotel or reservation service, you'll get the same quality of services every time. And I think that's why they're trying to protect it as a brand. It does have some distinctive logo design as well. I recall that in the Patent and Trademark Office, the applications actually are for distinctive colors in the mark and other designs of the mark. But at the bottom line, they want to protect that as their brand so that when Jeffrey or Rebecca or Corinne or I go to that site, we'll get the same quality of services every time as a brand.
Thank you for that. Well, it's time for closing arguments in this completely rich and rigorous discussion, which is all that I hoped it would be. The Supreme Court ended pretty well on time, and we will too. Rebecca, final thoughts, including I'm curious about to what degree are the policy considerations that we've discussed, namely the fear that a particular company like Booking.com could essentially monopolize the name and draw out competitors, to what degree are those legally relevant? Is there any room under the Lanham Act or under the court's precedent for the justices to take those into account? And although I do not want you to predict, because we are here to learn rather than to be pundits, maybe you could sum up, based on the oral argument you just heard, the major considerations that different justices expressed that you think might be significant as they help to decide the case.
So, thank you. Just very quickly, I do want to say that everybody used trademark as a synonym for register. It's actually not really the same thing, and I did it too, but there are a lot of trademark lawyers feeling a little sad right now because the oral arguments conflated trademark with registration, and this is actually a point related to the core of the case, which is even if you don't have a registration, there are circumstances where you can act against bad actors. And so I think the court was sensitive to these questions of monopolization and what are the appropriate remedies. And, you know, if Booking.com is asking for such a tiny, tiny right, and it's not objecting to all these other legitimate competitors, what is it actually asking for? Like, why is it here if the right will not extend past exact copies, which, and I think Margaret is exactly right about what they're interested in. But of course, they have the registration, the domain name registration for Booking.com, so they can completely control the quality of the services they deliver. There is no problem that trademark is able to or necessary for solving in terms of what's on Booking.com. So I think the justices are going to be struggling with reconciling what Booking is asking for with the kind of core justifications for trademark policy, and I think they will want to say that the statutory language answers it completely, but since it doesn't, they will inevitably have to do something. And I won't predict because I don't think it's predictable.
Wonderful. Thank you very much. They will have to say the statutory language covers it, but it doesn't, so they will have to do something. It's a wonderful summary of the challenges that face the court. Corinne, this is a sort of closing argument for the petitioner side, but based on what the oral argument you just heard, why do you believe that the court should adopt the rule you've argued for, and what in the argument that you just heard makes you think that they might?
So I think there's no getting away from this decision, whatever decision they make, as being a policy decision. They have to make a choice. And when they make this decision, they're going to have to look for, they should consider what's the most pro-competitive move we can make. When we think about trademark policy has always tried to take into account the risk of over-controlling language, the risk of shutting down competition unfairly. They also need to look at what are the other tools in Booking.com's toolkit, because they'll want to think about what are the consequences for them. And of course, Booking.com has many other tools in its toolkit, as Professor Tushnet has pointed out. You can look to unfair competition law, and you can also just look at the economic advantage that it already has. Taking all of that into account, it seems to me that what the court should do is follow one of the sort of bedrock trademark policy choices, which is that when you have made a choice, when you set up your business to adopt a generic name, you have to accept the consequences of that choice. And that, the advantage that gives you commercially, combined with the advantage that you get when you've already registered the domain name, is enormous.